Dear learners, I am Dr. Nisha from Chandigarh University, Chandigarh. Welcomes you all to understand the concept of hierarchy of courts under the course on legal methods and systems. This lecture has been divided into two parts. The first part, we are going to learn about the concept of hierarchy of courts, and in the second part, we will learn about the relationship between high courts and the subordinate courts. So now let's discuss about the concept of hierarchy of courts. In the part 1, we will discuss about the introductory part. The Indian judicial system is a cornerstone of the country's democracy and governance. As one of the oldest legal systems in the world, it has evolved over centuries, adapting to the changing needs of society while upholding the rule of law. The judiciary in India is tasked with the critical role of interpreting laws, resolving disputes and ensuring justice. Its hierarchical structure defined by the Constitution and various statutes, including the CRPC, is designed to facilitate an efficient and equitable justice delivery system. The hierarchy of court in India is essential for maintaining order and consistency in the administration of justice. This structure allows for a systematic appeal process, ensuring that individuals have the opportunity to seek redress and that higher courts can correct errors made by lower courts. So, the Supreme Court of India sits at the apex court, followed by high courts in each state or group of states, and then the subordinate courts, including district and session courts, magistrate courts. This layered system ensures that legal matters are addressed at the appropriate level and provides a mechanism for oversight and review. I hope you are getting my concept. Now we'll discuss about the historical evolution of the Indian judiciary. So, the Indian judicial system has a rich and complex history marked by significant transformations from ancient times through the colonial period to the present day. So, understanding this evolution is crucial for comprehending the current structure and functioning of the judiciary, particularly in the context of criminal justice as outlined in the CRPC. So, now we will discuss about the ancient era. In ancient India, the judicial system was deeply intertwined with religious and social norms. Justice was administered by village assemblies known as panchayats, which consisted of respected elders from the community. These assemblies resolved disputes based on customary laws and traditions prevailing in that religion. Kings also played a very significant role in the administration of justice. They were considered the ultimate authority with royal courts that addressed more serious offences and complex disputes. The King's Court was supported by a network of local courts and officials who helped in dispensing justice at various levels. The primary focus of the ancient judicial system was to maintain the social order and harmony with the community. Now we will understand the concept of pre-colonial judicial system. During the Sultanate and Mughal periods, the judicial system underwent considerable changes. The Sultanate period, which is during the time of 1206 to 1526, saw the introduction of Islamic law or Sharia, which coexisted with the Hindu customary laws. Qazis, Islamic judges, were appointed to administer the justice according to the Islamic principles, particularly in matters of criminal law and personal disputes among Muslims. The Mughal era, which is 1526 to 1857, further consolidated the judicial structure. Emperor Akbar, one of the most notable Mughal rulers, introduced significant judicial reforms, including the establishment of separate courts for civil and criminal cases. The Mughal administration also maintained a hierarchy of courts, with the emperor's court at the top, followed by provincial courts, district courts and local courts. So now let's understand about the concept of colonial or British era judicial reforms. Basically, the advent of British colonial rule brought about profound changes in the Indian judicial system. The British East India Company initially administered justice through a system that combined traditional Indian laws with English legal principles. However, as British control expanded, there was a push for a more standardized and unified legal system. Several key reforms during the colonial period laid the foundation for the modern Indian judiciary includes Regulating Act of 1773. This act helped us to establish the Supreme Court of Judicature at Fort William, Calcutta, marking the beginning of a formal judicial structure under the British rule. Then Charter Act of 1833 created the Law Commission to codify Indian laws, leading to the formulation of the Indian Penal Code and the Criminal Procedure Code that continued to be followed even in the independent India. Indian High Courts Act of 1861 established high courts in Bombay, Madras and Calcutta, replacing the earlier Supreme Court and Sadar Adalats. These reforms aimed to create a more uniform legal system, reduces arbitrariness and ensure greater consistency in the administration of justice. Now we will discuss about the post-independence judicial framework. So following India's independence in 1947, the Constituent Assembly drafted a new constitution which came into effect on 26 January 1950. The Constitution of India established an independent judiciary free from executive influences and laid down the structured jurisdiction of various courts. So, the Supreme Court of India was established as the highest judicial authority with high courts at the state level and subordinate courts at the district and local levels. So, the judiciary was entrusted with the responsibility of upholding the constitution, protecting fundamental rights and ensuring the rule of law. So, the CRPC enacted in 1973 replaced the colonial era Criminal Procedure Code of 1898. It provided a comprehensive framework for the investigation, inquiry, trial and execution of criminal cases. The CRPC basically sought to balance powers of law enforcement agencies with the rights of the accused, ensuring a fair and just legal process. So, now we will discuss about the structure of the Indian judicial system. So, basically the Indian judicial system is a well-defined hierarchical structure that ensures the administration of justice across various levels. It operates under the framework established by the Indian Constitution and specific statutes, including the CRPC Code of Criminal Procedure. Now we will discuss about the overview of the Indian Constitution and judiciary. So, the Indian Constitution adopted in 1950 serves as the supreme law of the land. It establishes the framework for the Indian judiciary, emphasizing the independence of the judiciary from the executive and legislative branches of the government. So, we have the key provisions related to the judiciary, which include Articles 124 to 147. These articles pertains to the Supreme Court of India, its powers, jurisdiction and appointment of judges. In Articles 214 to 231, these articles deals with the high courts in states, their establishment, jurisdiction and powers. Article 50 mandates the separation of the judiciary from the executive in public services. So, the judiciary's primary role is to interpret the constitution, adjudicate disputes and protect our fundamental rights. So, its structure is designed to ensure access to justice at multiple levels with a clear appellate mechanism. So, now we will discuss about the concept of classification of courts, civil and criminal jurisdiction. The Indian judicial system is broadly classified into civil and criminal courts, each dealing with specific types of cases based on their nature and subject matter. Civil courts, these courts handle disputes between individuals and organizations over their rights, like property, contracts and personal matters. The hierarchy of civil courts includes district courts at the district level. These courts handle significant civil cases and serve as the primary courts of original jurisdiction. Subordinate courts below the district courts are various subordinate courts such as Munsif's courts and civil judge junior division courts dealing with less significant civil matters. Criminal courts, these courts deal with the offences against the state or public, such as crimes involving personal harm, theft and other criminal activities. The hierarchy of criminal courts includes session courts at the district level. These courts handle serious criminal cases such as those involving severe penalties. Magistrate courts below the sessions court, these include chief judicial magistrates, judicial magistrates first class, judicial magistrate second class and executive magistrates, each with varying degrees of jurisdiction and their powers. So, constitutional provisions regarding judiciary. The Constitution of India provides a robust framework for the functioning and independence of the judiciary. Some of the critical constitutional provisions related to the judiciary are Article 124, which establishes the Supreme Court of India, specifying the appointment, tenure and removal of judges. It ensures the Supreme Court's role as the apex court and guardian of the Constitution. Article 126 deals with the appointment of acting Chief Justice in the Supreme Court. Article 127 provides for the appointment of ad hoc judges in the Supreme Court if the required quorum is not met. Article 128 allows retired judges of the Supreme Court or High Courts to sit and act as judges of the Supreme Court. Now, Article 129 declares the Supreme Court as a court of record, having all the powers of such a court, including the power to punish for contempt of itself. So, now Article 131 to 134 defines the original appellate and special leave jurisdiction of the Supreme Court. Article 141 states that the law declared by the Supreme Court shall be binding on all courts within the territory of India. Article 214 establishes High Court for each state or group of states, specifying their powers and functions. Article 226 empowers High Courts to issue certain writs for enforcement of our fundamental rights and other purposes. Article 227 vests High Courts with the powers of superintendence over all courts and tribunals within their jurisdiction. And Article 233 to 237 deals with the appointment, conditions of services and tenure of district judges and other judicial officers in the states. The hierarchical structure supported by these constitutional provisions, which ensures a systematic and orderly administration of justice. The classification divided into civil and criminal jurisdictions allows for specialization and efficiency in handling different types of legal disputes. The independence and authority granted by the Constitution empower the judiciary to act as a guardian of the rule of law and protect of citizens' rights. Now we will discuss about the Supreme Court of India. The Supreme Court of India, established under the Constitution, is the highest judicial authority in the country. So, it plays a pivotal role in the interpretation of the Constitution, adjudication of disputes and protection of fundamental rights. The Supreme Court of India was established on 28 January 1950, 2 days after the Constitution of India came into force. It succeeded the Federal Court of India, which was established under the Government of India Act 1935. The Supreme Court is constituted under Article 124 of the Constitution, which outline its composition, powers and functions. It originally consisted of a Chief Justice and 7 other judges. Over time, the number of judges has been increased to accommodate the growing needs of the judiciary. As of now, the Supreme Court comprises the Chief Justice of India and up to 33 other judges. Judges of the Supreme Court are appointed by the President of India. The Chief Justice is appointed based on the seniority basis, while other judges are appointed based on the recommendations made by the Chief Justice and the Collegium of the Supreme Court. Judges hold office until the age of 65. They can be removed by the President on grounds of proven misbehavior or incapacity, following a process of impeachment by Parliament. Jurisdiction of the Supreme Court. Now, let us discuss about the jurisdiction. So, basically, the Supreme Court has comprehensive jurisdiction, encompasses original appellate and advisory functions. So, if we will discuss about the original apex, the Supreme Court has exclusive authority to adjudicate disputes between the Government of India and one or more states or between 2 or more states. This jurisdiction is outlined in Article 131 of the Constitution. It also has original jurisdiction in matters concerning the enforcement of fundamental rights. Article 32. Appellate jurisdiction. The Supreme Court hears appeals from judgments from high courts and other tribunals in civil, criminal and constitutional cases. So, this jurisdiction is detailed in Articles 132 to 136. Appeals can be made on grounds of substantial questions of law for significant legal interpretations. If we will discuss about the advisory part, then advisory jurisdiction has been defined under Article 143. The President of India can refer question of law or fact to the Supreme Court for its opinion. The court's advisory opinion is not binding. We will discuss about the powers and functions of the Supreme Court. Then, the Supreme Court's powers and functions are extensive, making it a cornerstone of the Indian judiciary. It ensures that laws and executive actions are in compliance with the Constitution and has the power to strike down laws that violate our constitutional provisions. The Supreme Court has the authority to review legislative and executive actions to ensure they do not contravene the Constitution. This power is inherent in its role as the guardian of the Constitution. It interprets laws and statutes, providing a clarity and consistency in legal principles, which serves as precedents for lower courts, the court also plays a crucial role in protecting citizens' fundamental rights. It has the authority to issue writs such as habeas corpus, mandamus, prohibition, quo warranto and certiorari to enforce these rights. If we will discuss about the powers of High Court, then High Courts occupy a significant position in the Indian judicial hierarchy, acting as the principal courts of justice in each state or group of states. The High Courts are established under Articles 214 to 231 of the Indian Constitution. So, each state or group of states has its own High Courts. The President of India appoints the Chief Justice and other judges of a High Court after consultation with the Chief Justice of India, the Governor of the state, and in the case of appointing a judge other than the Chief Justice, the Chief Justice of the High Court concerned. So, now we will discuss about the jurisdiction of the High Courts. High Courts have a wide range of jurisdiction, including original, appellate and supervisory jurisdiction. They have original jurisdiction in civil and criminal matters within their territorial limits and can hear cases directly without the case first going through lower courts. They also have original jurisdiction in matters of fundamental rights where they can issue writs such as habeas corpus, mandamus, prohibition, quo warranto and certiorari. Under Article 226 of the Constitution, High Courts hear appeals from judgments and orders of subordinate courts and tribunals within their territorial jurisdiction. This includes both civil and criminal appeals. They have the authority to review cases and reverse or modify decisions made by lower courts. Under Article 227, High Courts have the powers of superintendence over all courts and tribunals within their territorial limits, ensuring that lower courts function within the bounds of their authority and adhere to the correct procedures. If we will discuss about the powers and functions of the High Court, then High Court can review and strike down laws and executive actions that violate the Constitution or any other law in force. Basically, this ensures that legislative and executive branches act within their legal boundaries. They can issue writs to protect our fundamental rights and enforce the legal rights of the individuals. This jurisdiction is broader than that of the Supreme Court, as it includes only fundamental rights but also other legal rights. High Court oversees the functioning of subordinate courts, ensuring their efficient operation. This includes the power to transfer cases from one court to the another court and to withdraw the cases from subordinate courts. They also interpret laws and statutes providing guidance and precedent for lower courts and legal practitioners within their jurisdiction. So, this was all about today's lecture. Please take care till we meet again with another interesting lecture. Bye for now.